Excellent. Good afternoon. My name is Dave, and for the next 12 minutes or so, I'm going to talk to you about the tensions between US government access and the GDPR. But first, I'll introduce myself. So as I said, my name is Dave. I work for the Cloud Legal Project at Queen Mary, University of London. For the past 8 years or so, I've been researching the legal implications of using and providing cloud services, and our research is funded by Microsoft. I also teach cloud computing law both at Queen Mary and at the London School of Economics. And the findings I'm sharing with you today are based on research which I conducted together with Professors Christopher Millard, Ian Walden, and Ulrich Vermeling. And so as I said, our research has looked at this tension between US government access powers and European data protection law. And the first thing we always acknowledge is that this is not a new topic, right? In fact, it's been the subject of intense discussions at least since the Snowden revelations of 2013. That said, a lot of the existing discussion is focused on questions around international data transfers and the lawfulness of those transfers under Chapter 5 of the GDPR, including following cases like the Schrems 1 and 2 cases, which dealt with the adequacy, the previous adequacy decisions for transfers to the US. So we take a different approach. Instead of focusing on data transfers, we instead look at the principles of lawfulness, purpose limitation, and security under Chapters 2 and 4 of the GDPR. And we ask, can a cloud provider comply with its obligations under the GDPR when it discloses European customer data to the US government? And so to answer that question, we look at a very specific scenario. And so in our scenario, we have a customer that is established in Europe, right, within the EU, and they use the cloud services of a cloud provider that is the subsidiary of a US parent company, right? So we might think about, say, a company established here in Brussels that uses Microsoft Cloud Services, and they contract with Microsoft Ireland. And Microsoft Ireland is then wholly owned by Microsoft Inc. in the US. So what we have is a business-to-business cloud use case, and in the context of using the cloud service, the customer stores personal data in the cloud, right? And in doing so, effectively discloses that data to the provider's European subsidiary. And the provider's European subsidiary then stores that data on servers in Europe. So that's the starting point. Then what we have is a US government agency that wants to obtain access to that European customer data. So what they do is they issue a production order to the provider's US parent company, right? And they can do so either under the Stored Communications Act, as amended by the US Cloud Act for law enforcement purposes, or under FISA Section 702 for the purposes of obtaining foreign intelligence. Now, under both of those legal frameworks, it doesn't matter that the data are physically stored in Europe, because US production orders under the SCA and under FISA can have extraterritorial effect. That is, they can target data stored outside of the US. So when it comes to complying with that order, the provider has essentially two options, right? It might be that the US parent company has direct technical access to the servers in Europe, right? In that case, if they have remote access, they can simply access the data directly and hand it over to the US government. In another scenario, they might not have that technical access privilege, right? They cannot directly access the data themselves, but they can order their subsidiary to hand over the data and then hand the data over to the US government. So it's those disclosures of European customer data from the provider's European subsidiary and ultimately to the US government that we analyze under the GDPR. So that's the scenario. Let's look at data protection law. So in our research, we identify 3 areas of tension. That is, areas where that disclosure to the US government comes into conflict with the provider's obligations under the GDPR. And that is the question of processing without controller instructions, the question of lawful grounds for the processing, and the question of purpose limitation. And we argue that in each of those cases, a provider faces real compliance challenges when disclosing data to the US government. And so for the rest of this talk, I'll deal with each of those issues in turn. So what's the problem with processing without controller instructions? Well, the issue here is that the cloud provider was acting as a processor when it was processing the customer data on the customer's behalf in order to provide the service. However, when it receives the US production order, it now starts processing that same data on its own behalf as a controller, because the cloud provider acts as a controller for that disclosure. It determines the purposes and means, including the purpose to comply with the US order which it has received. We argue that this disclosure is not covered by the customer's instructions, including by the very standard and vague terms that are in providers' standard contracts. So why is this a problem under Article 29? Well, Article 29 says that a processor can only process data on controller instructions unless the processing is required by EU or member state law, not by US law. Right? So that exception does not apply when there is a legal obligation arising under US law. And so as a result, we argue that there is potentially a breach of the processor's duty under Article 29. So that's the first area. And then let's look at the question of a legal basis for this disclosure. Right? The disclosure is a form of processing, and the cloud provider, as a controller, needs to have a legal basis for that processing. So we looked at two options under Article 6. The first would be the need to comply with a legal obligation. Again, that applies to legal obligations arising under EU or member state law, not to legal obligations arising under US law. So 6.1c we don't see as an option. As ever, then, we are left with the lawful ground of last resort, which is legitimate interests, right? And we do recognize that a cloud provider has a legitimate interest in complying with a valid US order, right? If it doesn't comply, it'll face penalties under US law. But that interest needs to be balanced against the data subject interest, including the interest in not having their data disclosed to a foreign government under foreign law. And so we end up with this balancing of interests, right, which is complicated and ultimately will require a case-by-case analysis. But we can say that one factor that is generally relevant is the nature of the data which is to be disclosed. So if we're dealing, for instance, with special category data, then in addition to an Article 6 lawful ground, the provider will also need to be able to rely on one of the exceptions under Article 9. We also know that children's data deserve a higher level of protection, and that there are other types of data which are considered inherently more private, things like financial data or location data. So in all those cases, when we have these sensitive types of data, that would weigh against the provider's interests in disclosing under Article 6.1f. And if the provider cannot rely on 6.1c or 6.1f, then it's unclear what lawful grounds it would be able to rely on at all, in which case we again see a potential breach, in this case, of the principle of lawfulness under the GDPR. And the third area, final area we'll look at is the question of purpose limitation. So here the issue is that these data were initially collected by the customer for the customer's own commercial purposes. And the cloud provider is now effectively repurposing those data in order to provide access to the US government. And so there's a question whether that is potentially a secondary purpose compatible with the initial purpose under Article 6.4, or whether what we're looking at is processing for an incompatible purpose, in which case we would see a breach of the purpose limitation principle under the GDPR. So because of those three areas of tension, we argue that there is good reason to believe that a provider would breach the GDPR when disclosing European customer data to the US government. We have a paper on SSRN, which goes into all these points in a lot more detail. So if that's something you're interested in, then I recommend having a look. We cover those 3 points, as well as the question of security obligations under Article 32, and we also touch upon the issue of international data transfers under Chapter 5, and we argue that that issue is not fully resolved by the data privacy framework, at least not when it comes to disclosing data which are stored in Europe. Just in closing, then, I'll note this is an area of ongoing research for us. So we're also interested in what all of this means for the European customer and their obligations as a controller. So, there are questions around whether, as a European organization, you can use a cloud provider as a processor knowing that that provider is subject to US jurisdiction. What does this mean, for instance, for your duty as a controller to protect the confidentiality of personal data from unauthorized access, including access by foreign governments, and your duty as a controller to use a processor that offers sufficient guarantees of compliance? So especially in those cases of sensitive data, as I said, there's a question whether you as a European controller can use a US hyperscaler. And finally, we're interested in what European customers and we as Europeans can do to manage the risk of foreign government access, including potentially through organizational measures under contract and technical measures such as encryption. So this is all subject to our future ongoing research and potentially a forthcoming paper. As I said, the papers on SSRN, do have a look if you're interested, and thank you so much for listening.